Hi, my name is Jennifer Solak. I am an estate planning and probate attorney in Houston. And I wanted to kind of talk today about the different options that you have for giving an inheritance to a child. There's lots of different stages that, can be concerning. And so I'll address all the different types of protections that you can put in place to protect your children. Maybe they're minors and they're not ready to inherit any money yet. They wouldn't know what to do with it. But maybe it's an adult child that isn't the most financially savvy, or maybe it's an adult child with some substance issues or bankruptcy issues. And so there are things to put in place to protect inheritances around any of these scenarios. So what you don't want to do is you never want to list the name of a minor on a beneficiary designation or just give something to a minor outright because and this will happen if you do nothing as well, because if a minor is to inherit some money and they're under 18, legally they cannot manage that money. And so the court will then have to appoint a financial guardian to oversee the inheritance for that child, even if that financial guardian is the other parent of that child. And so that's just a lot of time and money involved. That's something that you would like to avoid. And even in that scenario, the child then or the young adult then receives the inheritance at 18 years old. And I don't know about you, but I was probably not ready to inherit a lot of money at 18. And most kids probably don't know really what to do. That would be a prudent choice if they were to inherit money at 18 years old. So there's some things we can put in place to avoid that scenario. And so you want to put trust provisions in place so that, if something were to happen, the child or the young adult or the adult child's inheritance will go into trust. And these are trusts that can be provisions included in a will or even in a living trust. They're different than a living trust because a living trust is something that's created right now. The trust provisions that are put in place for children are instructions for a trust to be set up if and when that time comes. And so when kind of looking at these different options for those kinds of trust provisions, there's really kind of a good, better, and a best choice. So a good choice is what we like to call the ages and stages distribution. And what this could look like, you can, of course, in whatever plan you choose, pick whatever ages you like. But it could be that somebody else you trust is managing the money for the child until they're 25 years old. And then at 25, they get a third of the money outright. At 30, they might get another third. And then at 35, they could receive the remainder that's left outright in their own personal name. So that's a good choice because it definitely protects that money against any immaturity of the child. It might not be the best choice because what sometimes happens in that scenario is that, if, a 35-year-old or anybody receives that kind of money, the natural choice would just be to put it in the joint checking account with a spouse, or maybe they go invest in a business with a friend. And in doing so, their inheritance that they received really loses its separate character, becomes commingled. And so they might not have as much right to that money or the appreciation of that money in the future. So a better choice would be to leave the inheritance in the trust for the child's lifetime. And, at 25, you can, they could become co-trustee with whoever you have named to manage their money. And then at 30 or whatever age you choose, the child could become the trustee of that trust. So they could have full control and management of that money, but the money stays in a separate legal entity. And so it's protected from probably they're commingling it with a spouse or a business partner. And so I kind of like to call that the divorce-proof trust because, it's less likely that they would then lose that money to, a divorce or a business divorce or something like that. The third option, kind of the best option, would be to create trust provisions where the money stays in trust for the child's lifetime. And you've named a third party to manage the money for the child. So there's a third party trustee. So instead of the child becoming the co-trustee at 25, It stays in trust for the child's lifetime, and you can name another person to be trustee of that trust, or you can name a bank. Some people or some companies that provide professional fiduciary services. And the great thing about that choice is that not only is that inheritance kept separate for that child, any appreciation is kept separate, it stays out of the child's estate. But because the child does not control the money, it is also protected from creditors, bankruptcy, divorces, and things like that. So there is more complete asset protection with that type of trust. And so I just go through all these options because they all exist. They're all there. They're all better choices than the alternative that we talked about in the beginning, which is just doing nothing or naming a minor in their own name. And so you can kind of determine or talk with your attorney about what would be the best choice for your scenario. So I hope you found this helpful. If you did, please click the subscribe link below so I can be sure to make more videos that are helpful for you. Thank you so much. Bye.